Hi, my name is Joe Bartolomeo. I'm an Oregon Social Security disability lawyer with offices in Astoria and Hillsborough, and I handle Social Security disability claims in front of the Office of Hearings and Appeals, mostly in the Portland office, the Portland, Oregon office. And in today's video, I'm going to talk about the importance of your past work when Social Security is looking at whether to grant your application or deny your application for disability benefits. Now, I have another video that walks through what is called the sequential evaluation process. It's the 5-step process that Social Security goes through when it decides whether you're disabled or not. And I'll quickly review it, but if you want to look at that in more detail, you can check out that video. So, number 1, have you been working since the date you're claiming your disability began? If yes, you keep going. If no, your claim is denied. Number 2, do you have a medically determinable impairment? The shorthand for that is, do the medical records show that you have a problem, and does your problem affect your ability to work? Number 3, do you meet an impairment listing? That means, is your case a no-brainer? And Social Security decides that by looking at its checklists, which they call impairment listings, and if your medical records meet the checklist items, you're disabled. But if you're not, you still get to keep going. Number 4, I think, what is your residual ability? That means, what can you still do in a work setting? How much can you lift? How much can you carry? How long can you sit, stand, crawl, crouch, kneel, that kind of thing. Then we get into what you're able to do in terms of your past work. And that's where I want to go with this video. So, once Social Security figures out what your residual abilities are, then what it will do is go back and look at the past work that you've done and see whether you can go back to any of your prior jobs based on what Social Security thinks you can and cannot do. So, I'm going to talk about a case that I looked at today. My client worked mainly in the construction field. She did carpentry, framing, that kind of thing, and that's heavy work. So she listed that as one of her past jobs. But also, she worked as a sales clerk in a retail setting that did not involve as much lifting and carrying. So that's what I would call a light job. Now, when I say heavy and I say light, there are definitions for that. I mean, we have our understanding of what heavy work is. So when I tell a client, you know, what I do all day is sit around and look at a screen, I don't have to lift a finger, I really don't do anything physically at work, that's sedentary work. So I think you get the point. So why is this such a big deal? Well, once Social Security figures out what they think you can and cannot do, they're going to go back 15 years from the date of your alleged onset and look at all the jobs that you have performed and worked. The alleged onset is the date that you're claiming your disability began. So if we alleged an onset date of June 1st of 2018, Social Security will go back to June 1st of 2003 and look at all of your jobs. And there are 2 things that they're interested in. Number 1, what is the skill level of that job? Number 2, what are the exertional requirements of that job? And that's what I was just talking about with light, heavy, sedentary work. If Social Security thinks that you can go back to any of those jobs, it's going to find that you're not disabled. That's why it's important for you to describe the jobs that you worked before you stopped working in great detail, because it can be a win or lose difference, or it can, it can make or break the case. I had another case where my client was a sales representative, which normally would not involve really physically demanding work, but the product that she sold, she also had to deliver, and it could be quite heavy. And that was a game changer in her case. Another factor that will influence the decision when looking at your past work is your age. If you are under 50 years old, if you're not able to do any of your past work, for example, if you were a construction worker and you can no longer do heavy work, but you could be a cashier or a ticket taker at a movie theater, which is light work or sedentary work, then if Social Security thinks you're still able to do light or sedentary work, even if it's unskilled, minimum wage, entry-level work, you will not be found disabled. But if you're 50 years of age and older, a new set of rules takes effect, and essentially the Social Security Administration will or could find that you're still disabled even if there is some work out there that you can do. So there's one set of rules for workers from 50 to 55 years of age. There's another set of rules for workers that are 55 to 60. And then there is another set of rules if you're over 60 up to retirement age. And generally speaking, the older you are, the less Social Security expects you to adapt to other work. And it gets fairly complicated depending upon your age bracket, but those rules are called the grids. And I talk about that in some other videos if you want to look into that in more depth. But what I tell my clients is this is the one time that it's an advantage for you to be older, because you may technically still be able to do certain kinds of work, but you will still be found disabled. So, again, to recap this, the importance of your past work, and as you describe it, is that Social Security is looking whether you can go back to any of your old jobs. And the other reason it's important is because depending on your age, it may be that you're still able to do certain kinds of work, but if you have a history of very strenuous work or work that's not very skilled, that's actually an advantage for you if you're an older worker trying to prove that you are eligible for benefits. Now, the Social Security can get really complicated. If you have questions, you can check out my free guide, the Social Security Disability Guide. It's an ebook, it's downloadable. It doesn't cost anything. We don't sell your contact information. You can also check out the website. I post articles with frequently asked questions or longer articles that dive pretty deeply into certain issues. And of course, if you need to contact us, we have a contact button on the website. And if we're not able to help you, we can point you in the right direction or get you referred to somebody who can. You can always call us. That's fine too. I always like to say this: if you have a denial of a claim, keep in mind that you have only 60 days from the date of that letter to deny, or excuse me, to appeal your denial. So keep that in mind. I hope this video helped you. Thank you so much for watching. Take care.